Now we consider relevance and reasons for excluding relevant evidence. The National Conference of Bar Examiners doesn't think this material is very important. It isn't heavily tested on the multistate. But this material can be at the core of essay questions on evidence. Understanding how to think about relevance is really centrally important if you want to write good evidence essays. So, we start with the threshold idea from the Federal Rules of Evidence that all relevant evidence should be admitted unless there is a good reason not to admit it. So we begin with the idea of logical relevance. It's very simple and straightforward. An item is logically relevant if it relates to the time, event, or person in controversy and tends to prove a fact that is germane to the dispute between the parties. Logical relevance is really quite simple. So, on an essay, the starting point is to identify the item of evidence and to explain its logical relevance. Now, the court has the discretionary authority to exclude even relevant evidence and even evidence that isn't subject to other objections. If the court determines that the evidence, although logically relevant, would unfairly prejudice the dispute, the judge can exclude that evidence. And it's also possible for the court to use justifications of confusion or time management to exclude logically relevant evidence. But the basic idea here is we begin by thinking about an item of evidence with regard to logical relevance. What does the evidence tend to prove? Why is the party that is offering this evidence eager to get it admitted? Now, we turn our attention to the more complicated issue, which is legal relevance. Relevance breaks up into logical and legal relevance. The real issues are with regard to legal relevance. We've already seen that the court has got the discretionary authority to exclude evidence where the court concludes that the probative value is substantially outweighed by unfair prejudice or other technical reasons. Where the material is most tested is with regard to the public policy reasons for excluding relevant evidence. And the most common area tested here, both on the multistate and also on the essays, is the issue of settlement offers. We know that liability insurance isn't admissible to show negligence or to prove that a party has the ability to pay damages, but liability insurance is admissible to show ownership and control. Similarly, subsequent remedial measures are not admissible to show liability, but they are admissible to show ownership and control. Settlement offers is where the real action is with regard to the public policy reasons for excluding relevant evidence. And the reason why settlement offers are heavily tested is because there are a couple of fine-line distinctions that come up all the time. The basic rule with regard to settlement offers is that offers to compromise and all statements made in that context are not admissible to prove liability. Offers to compromise are admissible when the plaintiff is suing to enforce an offer that was accepted. The common fact situations in which this arises are, after an accident, the defendant says, "I'm very sorry, it was my fault. My insurance will cover it." The apology is not admissible, and the mention of insurance not admissible. Suppose we've got a situation where there is an accident, and the defendant says, "I'm sorry, it was my fault. I will pay for all of your injuries." Again, completely inadmissible. Now, compare those two statements with this one. A person comes up after the accident, the defendant, and says, "I'm really sorry. I will offer to pay your medical expenses." Now, under these circumstances, the admission is admissible. And, of course, the offer to pay medical expenses are not admissible. That's a very commonly tested issue with regard to settlement offers, and I think you can pretty much count on seeing it in your practice. Also, plea negotiations in criminal court typically are inadmissible because we want to foster settlement in the criminal courts just as we wish to foster settlement in civil court. The final big area with regard to relevance is character evidence. character evidence is very commonly tested on the essays, and you're likely to get 1 or 2 questions about it on the multi-state. But again, remember that relevance and the reasons for excluding relevant evidence are not very important on the multi-state. They are far more commonly tested on the essays, as you'll see when we get into the hypotheticals that we'll do together. So, as we consider issues of character and concepts related to character evidence, remember that we do so from the perspective of relevance. A lot of character evidence is relevant logically, but we exclude it from admission anyway. This material is technical, and it is complicated. You'll learn a lot of the details by studying it through practice, but I can give you the basics in very little time, and you'll find that a glib familiarity with the basics will at least give you something to work with. As you practice, you will refine your understanding quite a bit more. So, as we consider character and related concepts, we are thinking about opinion, reputation, and specific acts. And of these 3, specific acts probably is the most complicated and, therefore, the most commonly tested. With regard to character evidence, we first must consider the distinction between civil court and criminal court. In civil court, character evidence typically isn't admissible. So, if we've got plaintiff versus defendant in contract or tort or real property or wills or trusts or any other subject that is not criminal litigation, evidence of a character quality to show propensity to act in accordance with that trait is inadmissible. So, if we've got a contract case in which A is suing B for breach, B can't bring witnesses to court to vouch for B's honesty or reputation for honesty. Evidence of character typically is not admissible in civil court. Now, there are instances in which character is an element of civil litigation. A good example would be negligent entrustment. Suppose A is suing B, and the basis of the lawsuit is A is alleging that B negligently entrusted his vehicle to C. Well, then C's character becomes at issue, because in order to determine B's negligence, we have to judge whether or not a reasonable person would have entrusted a vehicle to C. Thus, we have to examine what qualities C might have that would make C a bad driver. So, the basic idea here is character evidence is not admissible in civil litigation unless character really is a relevant element of that litigation. Now, compare that to criminal court. Typically, in criminal court, only the defendant can initiate litigation about character, because a criminal charge in and of itself is not an allegation of character evidence in the way that we're thinking about here. Remember that in criminal court, the defense can present opinion and reputation evidence of character traits that are inconsistent with the criminal activity that is alleged by the prosecution. And also remember that once the defense opens the door, the prosecution can offer rebuttal evidence. Next, we consider methods of proving character. And here, the most commonly tested issue again relates to specific acts. And the most sensitive area of specific acts evidence is with regard to the past sexual history of a rape victim. Here, there are strict restrictions against doing a character assassination on a rape victim. Still, the past sexual history of the alleged rape victim with the defendant or with some other person at the time of the rape can be admissible pursuant to the exercise of judicial discretion. Habit and routine practice also are fairly commonly tested, both on the essays and on the multi-state. Although not in great depth, habit and routine practice evidence is admissible to show a person's regular response to a specific set of facts when that is relevant to the subject matter of the litigation. And it is relevant to prove that the person acted in conformity to the habit on the day and time in question. Now, compare habit and routine practice evidence to evidence of other crimes and acts or previous transactions or events. These bits of evidence are not admissible to show character, but they are admissible pursuant to the mimic rule. And remember what mimic stands for: motive, intent, absence of mistake, identity, or common scheme or plan. That's mimic. Also remember that conviction of some underlying crime need not be proven, only that the act occurred. Now, compare specific acts evidence with similar events evidence. Here, often we're talking about evidence involving accident scenes. We know that a defendant typically is not allowed to come to court and claim that there were thousands of identical parties going through the location of an event and none of them were hurt, like the plaintiff was. That's not admissible evidence. But under certain circumstances, the plaintiff can offer evidence that other people were injured in the same circumstances as the plaintiff. But here, the probative value has to be compelling. In other words, the circumstances of the other injuries have to be strikingly similar to those that the plaintiff is alleging. So that wraps up a quick consideration of relevance and reasons for excluding relevant evidence. Obviously, if you've studied this material at any depth, you'll appreciate that what I have just done in this brief video is go over the highlights of where the testable issues are and what the key rules are. As you engage in practice, you'll see how the material is tested, and you will develop a sharper understanding of the fine-line distinctions that are required to do a really effective job responding to one of the questions presented by this body of material. Next, we're going to consider real, demonstrative, and experimental evidence.